Hello and welcome to this joint ProCon Nottinghamshire and Leicestershire webinar. I'm Will Kersham and I'm Chair of ProCon Nottinghamshire. ProCon has been connecting professionals in property and construction since 2018 in Nottingham and since 2000 in Leicestershire. We now boast a combined membership of more than 1,000 people. We hope that many of our members have joined us today to listen to this webinar. However, we're always looking for more people to join the network, so if you're not a member and are interested in finding out more, please drop us an email at info@procon-nottinghamshire.co.uk for Nottinghamshire, info@procon-leicestershire.co.uk for Leicestershire, or you can give us a call on 07803 126 807. Today, we're going to take a look at some of the recent planning changes announced by the government, including changes to permitted development rights and use classes, as well as looking at the planning white paper, Planning for the Future, which the Prime Minister described as radical reform unlike anything we have seen since the Second World War. Paul Wakefield from Shakespeare Martineau will look at the planning white paper and give some thoughts as to whether the proposed changes are as radical as the Prime Minister would lead us believe. Tony Aspbury of Aspbury Planning will then look at the changes announced to use classes and permitted development, which took effect at the beginning of September, and what those will mean in practice. We'll also be hosting a live Q&A session at the end of the webinar with assistance from Daniel at Cartwright Communications, where Paul and Tony will answer your questions. If you have a question, simply type it into the box below and we'll be answering these in a little while. You can also use the upvote function if you see a particular question you'd like to know the answer to. So please make use of this, as we'll be able to make sure we answer the questions that you're most interested in. So, without further ado, let's hear more about the white paper from Paul Wakefield.
As you may or may not be aware, there have been a raft of planning changes which have been pushed through or proposed in recent months, and the purpose of today is to hopefully give some thoughts on some of those changes. I'm going to briefly cover two matters. Firstly, I'm going to give a very quick overview of the white paper, which was recently published by the government, which the Prime Minister described as radical reform unlike anything we have seen since the Second World War. Given that modern planning is widely regarded as being brought in 1947, 2 years after the Second World War, it's possible that some of us might consider the creation of the planning system as we know it to be a more radical transformation than anything now being proposed, but we mustn't let facts get in the way of a good soundbite. Secondly, I'm going to look at the legal changes which have been made to the Use Classes Order, or to give it its full title, the Town and Country Planning, open parentheses, Use Classes, close parentheses, open parentheses, Amendment, close parentheses, open parentheses, England, close parentheses, Regulations 2020, which I'm sure we can all agree trips off the tongue nicely. As you may have seen in the press, on the 6th of August, the government published a white paper entitled Planning for the Future, which sets out the whole-scale changes which they are proposing to the planning regime. Heralded by forwards from both the Prime Minister and the Secretary of State, Robert Jenrick, the white paper covers three areas: planning for development, planning for beautiful and sustainable places, and planning for infrastructure and connected places. Now, in its own words, the white paper states, the starting point for an effective planning system is to establish a clear and predictable basis for the pattern and form of development in an area. The current system of land use planning in England is principally based on local plans, brought forward by local planning authorities on behalf of their communities. But in contrast to planning systems in places like Japan, the Netherlands and Germany, where plans give greater certainty that development is permitted in principle up front, plans in England are policy-based, with a separate process required to secure permission on the sites that it designates for development. Local plans are a good foundation on which to base reform, as they provide a route for local requirements to be identified and assessed, a forum for political debate and for different views on the future of areas to be heard. The National Planning Policy Framework provides a clear basis for those matters that are best set in national policy. However, change is needed. Layers of assessment, guidance and policy have broadened the scope of local plans, requiring a disproportionate burden of evidence to support them. As a result, local plans take increasingly long to produce, on average over 7 years, have become lengthier documents of increasing complexity, in some cases stretching to nearly 500 pages, are underpinned by vast swathes of evidence-based documents, often totaling at least 10 times the length of the plan itself, and none of which are clearly linked, standardised or produced in accessible formats, and include much unnecessary repetition of national policy. It goes on to state that local plans should focus on where they can add value and should be based on transparent, clear requirements for local authorities to identify appropriate levels of and locations for development that provide certainty and that applicants and communities can easily understand. They should communicate key information clearly and visually so that plans are accessible and easily understandable and communities can engage meaningfully in the process of developing them. They should be published as standardised data to enable a strategic national map of planning to be created. They should be developed using a clear, efficient and standard process. They should benefit from a radically and profoundly reinvented engagement with local communities so that more democracy takes place effectively at the plan-making stage, and they should set clear expectations of what is required on land that is identified for development so that plans give confidence in the future growth of areas and facilitate the delivery of beautiful and sustainable places. So what does the white paper propose? Well, land should be categorised into one of three categories: growth areas, renewal areas, and areas which are protected. Growth areas, as the name indicates, are areas which are suitable for development. Sites which are designated for growth would have outline approval for development. Essentially, these would be equivalent to allocated sites, but with the added benefit that their allocation would constitute the grant of an outline planning permission. Renewal areas. This would cover existing built-up areas where small-scale development is appropriate and including gentle densification and infill in residential areas, including small sites within or on the edge of villages, with a statutory presumption in favour of development on these areas, albeit they'd still need to secure planning permission in the usual way. Areas which are protected. Well, these are areas where development should be restricted, including greenbelt, areas of outstanding natural beauty, conservation areas, local wildlife sites, sites with significant flood risk or important areas of green space. It would also include areas of open countryside not earmarked for growth or renewal. And whilst I would expect there to still be some circumstances in which development in protected areas might be acceptable, as with the current regime, this will be very tightly controlled. Local plan policies would also be stripped back so that there wouldn't be a need to reiterate sections of the National Planning Policy Framework. One obvious consequence of this would be it would centralise control in the hands of the government, and regardless of their protestations to the contrary, it seems abundantly clear that the White Paper proposes a return to top-down planning and a decisive move away from localism. There's also a push towards stringent timelines for decision-making, which I suspect will only work if council planning departments are properly funded. Whether any of this is radical, or just a return to the way local plans worked 20 years ago, I'll let those of you who are old enough to remember decide. So a simpler, more streamlined system is proposed, but the White Paper makes clear that planning should be a powerful tool for creating visions of how places can be, engaging communities in that process and fostering high-quality development, not just beautiful buildings, but the gardens, parks, other green spaces in between, as well as the facilities which are essential for building a real sense of community. Local authorities are to be encouraged to produce design guides and codes to ensure beautiful building. Now, to my mind, the difficulty with any focus on building beautiful is, of course, that beauty is in the eye of the beholder, and this may lead to the homogenisation of areas rather than promoting diversity, probably one for the architects amongst us to ponder. Equally, beauty is only skin deep. Will the push to build beautiful come at the expense of building well? The White Paper also promises a quicker, simpler framework for assessing environmental impacts and enhancement opportunities. And whilst I don't think anyone would argue that the environmental impact assessment regime can be lengthy and time-consuming, I suspect the majority would also agree that understanding the likely impacts of a proposal are important to inform decision-making. The trick to any such proposal will therefore be to strike the requisite balance between speedy and comprehensive assessment of the impact, and it remains to be seen whether this is achievable. Thirdly, the White Paper looks at planning for infrastructure and connected places. Now, as the White Paper acknowledges, new development brings with it new demand for public services and infrastructure. Mitigating these impacts by securing contributions from developers and capturing more land value uplift generated by planning decisions to deliver new infrastructure provision is key for both new and existing communities. It's also central to our vision for renewal of the planning system. In its own words, the government say they will improve infrastructure delivery in all parts of the country and ensure developers play their part through reform of developer contributions. They propose the Community Infrastructure Levy and the current system of planning obligations will be reformed as a nationally set value-based flat rate charge, known as the Infrastructure Levy. A single rate or varied rates could be set. They will aim for the new levy to raise more revenue than under the current system of developer contributions and deliver at least as much, if not more, on-site affordable housing as at present. This reform will enable the government to sweep away months of negotiation of Section 106 agreements and the need to consider site viability. It will also deliver more of the infrastructure existing and new communities require by capturing a greater share of the uplift in land value that comes with the development. It will be more ambitious for affordable housing provided through planning gain and will ensure that the new infrastructure levy allows local planning authorities to secure more on-site affordable housing provision. And it will give local authorities greater powers to determine how developer contributions are used, including by expanding the scope of the levy to cover affordable housing provision, to allow local planning authorities to drive up the provision of affordable homes. It will ensure that affordable housing provision supported through developer contributions is kept at least at current levels and that it is still delivered on site to ensure that new development continues to support mixed communities. Local authorities will also have the flexibility to use this funding to support both existing communities as well as new communities. Now, according to the white paper, developer contributions currently deliver around half of all affordable housing, most of which is on site. The white paper proposes to largely do away with Section 106 planning obligations and instead allow local authorities to use funds raised under the infrastructure levy to secure affordable housing or through in-kind delivery on site, with the price differential between the unit being sold on the open market and the same unit being sold to a nominated affordable housing provider offset against the infrastructure levy liability, which the government thinks will incentivise the building of on-site affordable housing. Cynically, I'm not sure that every developer I've ever come across would take this option, or whether they'd rather pay the cash to the council and thereby be able to market a site with no affordable housing units on it. No doubt you will have your own thoughts on this. In the alternative, the white paper has suggested that it might be possible to create a right of first refusal for local authorities, or any affordable housing provider acting on their behalf, to buy up to a set proportion of on-site units at a discounted price broadly equivalent to build costs, albeit the developer would have discretion as to which units were sold in this way, and these units could be used as affordable housing or sold on at market price to allow the delivery of affordable housing units elsewhere. Again, cynically, I wouldn't be surprised to see developers grouping any such units together in one corner, far from the show home. Whether that's any different to the current system, again, I'll let you decide. The other point to note is that it suggested that local authorities could be given greater freedom over how to spend their infrastructure levy, or ill-gotten gains, if you will, once core infrastructure was delivered. Now, in practice, this could potentially break the current need connection which currently exists, with a need which is local to a development being deprioritised and thereby potentially left unmet at the expense of a political pet project elsewhere in a district. So that's a very brief overview of some of the themes and topics within the white paper. As mentioned before, this is currently only a consultation process and it remains to be seen what happens going forward. What is clear is the consultation closes on the 29th of October, so if you have strong feelings on the subject, I'd actively encourage you to engage in the consultation. Turning briefly to the new use classes regulations, I'll leave Tony to talk about potential practical consequences of the change, but in short, with effect from the 1st of September, the government has radically changed the way in which certain types of buildings are categorised in planning terms. Unlike the white paper, which could perhaps be seen as a return to planning as it was 20 years ago, this is a change which is potentially far more dramatic. The change has created two new use classes, Class E, Commercial, Business and Service, and Class F, Local, Community and Learning, which splits into Class F1, Learning and Non-Residential Institutions, and Class F2, Local Community. It also moves some uses that were previously covered by the Use Classes Order, and which benefited from certain permitted changes, into a list of uses which cannot be included in a specified class, otherwise known as sui generis. Class E will comprise the previous shops, A1, financial and professional services, A2, restaurants and cafes, A3, and offices, B1, together with uses such as gyms, nurseries and health centres, which were formerly D1 and D2. The new learning and non-residential institutions class, F1, will include former D1 uses, which are more likely to involve buildings in wider public uses such as schools, libraries and art galleries. Local community uses, class F2, will include former D2 uses, which provide for group activities of a physical nature such as swimming pools, skating rinks and areas for outdoor sports, and it also includes smaller shops serving local communities. Residential uses, class C, general industrial, B2, and storage and distribution, B8, remain unchanged. There are some transitional arrangements in place to allow for the use of historic permitted changes. However, these will only be in place until the end of July 2021, and the same is true of relevant Article 4 directions. Now, one caveat to this is that a judicial review of the changes has been lodged and is due to be heard in the second week of October, which, if successful, would see the changes quashed. In which case, it presumably won't just be the Home Office grumbling about the role played by activist lawyers in halting their attempts to act unlawfully. Those of you with long enough memories might remember similar challenges ensued at the time of the coalition government and their laboured attempts to do away with regional planning. In that instance, whilst the government were defeated in the courts, regional planning was ultimately scrapped through the introduction of appropriate primary legislation. In this instance, even if the changes are ultimately delayed, I'd expect that they'll still come forward, and as such it's a case of when, not if. For now, with the changes to the use classes order, it's a case of proceed on the basis that they are in place until that changes. Conversely, with the measures proposed in the white paper, they are a case of if not when, and I'd encourage you all, if you are interested, to read the white paper and engage in the consultation, which runs until the 29th of October, and to watch this space for further updates as and when the outcome of the white paper is released. Thank you.
Good afternoon, ProCon members. Well, it falls to me to discuss this afternoon changes to planning regulations in practice. My name's Tony Aspbury. I'm a director of Aspbury Planning, a Nottingham-based planning consultancy. So, changes to permitted development rights. In conjunction with changes to the Town and Country Planning (Use Classes) Order 1987, so-called UCO, which I discuss later, the government has introduced changes to the Town and Country Planning General Permitted Development England Order 2015, the GPDO. These changes to permitted development rights, that is, rights not requiring planning permission, allow additional stories to be added to dwelling houses, additional stories above commercial units to create a dwelling house, additional stories above an existing dwelling house to create residential flats, and demolition of buildings, either commercial or residential, and rebuilding for residential use. These changes are all subject to what is called a prior approval by the local planning authority process and to compliance with a number of set conditions, which are numerous and complex. In some cases, the process is as complicated as the original planning application process would have been. And there is also huge potential for neighbour disputes and litigation. And now move on to changes made to the use classes order. The stated aim is to provide flexibility of use for commercial premises by removing excessive red tape. And my question is, really? The new regulations seek to amend and simplify, quotes, the use classes system by, firstly, revoking parts A, retail, D, non-residential institutions and assembly and leisure uses, and B1, business, of the existing use classes order. That is classes A1, A2, A3, B1, D1 and D2. Introducing a new class E, commercial business and service, which is a combination of the previous A1, A2, A3, B1, part of D1 and part of D2 classes. Creating a new class F1, learning and non-residential institutions, and a new class F2, local community. And increasing the number of use classes that are sui generis, that is, Pubs, takeaways, cinemas, concert, bingo and dance halls have all been added. And this means that any change from or to these uses will require planning permission. Why have the changes been made? Well, consolidating uses is an attempt to add flexibility, provoke change and recovery for some uses, to allow businesses to be able to respond and adapt quickly to changing circumstances and demands. And these are said to be lessons learned from the COVID-19 pandemic. It's also to enable repurposing of buildings on high streets and in town centres to reflect changing retail and business models. The new Class E, commercial, business and service, also allows for a mix of flexible uses in different parts of the building and depending on different times of the day. And the new concept of local community uses, Class F2, has been introduced to ensure important community facilities are protected through the planning system. My question would be, is this a response to the COVID-19 pandemic? Were changes already happening or going to happen before through the process of planning applications? And might not this response be premature and or hurried? Remember that changes of use within a class do not require planning permission. So what's the impact? Well, the sheer breadth and inclusivity of the new Class E could, perversely, lead to the creation of a less diverse high street with a concentration of the most profitable uses. Diversity is by no means assured, therefore. It could exacerbate the speed of change we have already seen on our high street, but how sustainable is this change in the long term? Local planning policy and the MPPF will potentially be left behind and need to catch up quickly, and is that realistic? Generally, for example, there's been resistance in local and national policy to out-of-centre and out-of-town retail development due to the negative impacts on town centres. But the new Class E does not currently differentiate between town centre and out-of-centre or out-of-town sites. Thus, redundant out-of-centre health centres, offices, light industrial units and gyms could become retail or other Class E uses without the need for planning permission. And thus retail's flight from the high street could be accelerated. Also, buildings may not be suitable for direct conversion. And the current approach sees no control mechanism, for example, retail impact, sequential test, transport assessment, or impacts on the environment and amenity. Remember that more apparent flexibility in these orders does not mean that landowners can just go ahead. Questions to be asked are there applicable Article 4 directions restricting permitted development or changes of use? Is there any current or historic enforcement action on this site? Are any restrictions such as planning conditions attached to an existing planning permission and associated Section 106 planning obligations that could prevent the changes? Is there any need for listed building consent? Would a change need any external works that would require planning permission? For example, extensions, alterations to the external appearance of the building, or signage, etc. Are the building regulations requirements for change? Is any form of licensing required, for example, premises license and fire regulations? And finally, are there restrictive covenants attached to title deeds? So is it an opportunity? Well, the reform of the use classes order and the general permitted development order, alongside the unique economic context brought about by the COVID-19 pandemic, has the potential to provide the incentive for a new, flexible and agile high street and to deliver more needed housing. There is huge potential for flexibility given by the changes to allow developers, traders and landlords to mix uses and innovate and revitalise high streets. There's an opportunity to reevaluate current planning applications and permissions, and these changes could help you. You could consider the impact on your client's portfolio and on development proposals to identify future opportunities. But despite the apparent simplification agenda, there are lots of caveats, conditions and qualifications. The process is not simple or straightforward, and there are a number of potential pitfalls. So always take professional advice from someone such as ourselves. Thank you.
Huge thanks to both Paul and Tony for sharing some incredible insights into the new reforms and regulations that are being brought in by the government. So I'm now joined live by Paul and Tony. Thank you both for joining me. How are you?
Thank you.
Yeah, good. Thanks.
Fantastic. Well, it's good to see you both, and it's amazing to see so many people who have tuned in as well to today's webinar. So we're going to be hosting the Q&A now. Do please feel free to get your questions in, because we're going to have Paul and Tony with us until around 3 o'clock. So do keep your questions coming. But first, I've got a question for you, Paul. So just how overdue is this update to our planning system? Because of course it's being dubbed as the biggest reform since World War II.
So in terms of the change, successive governments throughout my career, I suspect throughout Tony's career, to be brutally honest, not giving anything away that he's a little bit longer in the tooth than I am, have sought to change the planning system because they see it as a very easy thing to do to hopefully stimulate housing growth and regeneration. To be brutally honest, I think the reality is that the problems with housing delivery aren't specific to the planning system. And it's just a very easy thing for the successive governments of whatever political hue they might be to target as a means of saying, well, that's the blockage, it's the planner's fault, which actually I think those working within the system would disagree with. That said, the planning system has been creaking for a little while, so anything that can be done to bring it into the 21st century, certainly with more technology, has got to be a benefit. And I think, there are real opportunities for change to hopefully drive the government's agenda to deliver more housing. What's perhaps a bit more interesting is that the white paper focuses very firmly on housing delivery. It doesn't look so much at what that means for office or commercial or the environment specifically. It's all about build, 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 houses, 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 because that suits their current narrative.
It's interesting, definitely. Now, Tony, I'm going to come to you for this next one. So how long do you think it will take us to start seeing the impact of these reforms? So are there any instantaneous kind of quick wins, as it were, that we'll be able to see within the next 12 months or so?
No, I don't think so, frankly. I think, just to echo some of the things Paul has said, what the white paper doesn't confront, and nor do the secondary changes that I've been talking about, is resource. And there's a fundamental problem in local government. We recognise that our colleagues in local government are severely under-resourced. And the second thing is, I think, which doesn't confront, is the political agenda. Planning is a political process, and a lot of the delays in the planning process are not down to procedures, they're down to political decision making. And so I think that this has the appearance of a quick win, but I don't think it is a quick win. And I think it's going to take a lot of working out in the process.
I'm going to put you on the spot. Is there any idea roughly of how long do you think it might take to start seeing things, or is it just too unknown at the moment?
Well, as Paul has unkindly pointed out, I've been in practice for 45 years, and there's nothing new to me. The process will go through the normal round of challenges. There'll be lots of there's always work for the lawyers in these changes, and there'll be plenty of work here. So I think it's going to take some time to bed down, but I would hope the government listens to some of the representations that are going to be made about this, because it's not a slick solution, and it's not a quick win.
No, absolutely. Now let's stick on the topic of kind of timing, because Paul, this next one's for you. Is there any indication on timing, for example, when the new rules associated with the white paper come into force, and how soon would LPAs be expected to take them into account?
So the consultation on the white paper runs till just before the end of October. From there, the government will need to obviously review the consultation responses that they receive and then take that forward, best guess sometime early 2021. That will probably take the form of primary legislation, so a new planning act in some form or guise, which would then need to obviously work its way through the House of Parliament before it then came into force. So best guess at the moment, I'd say you're probably looking middle 2021 before we see the legislation, possibly a bit earlier. I imagine the government might have a few other things on their mind in the meantime with Brexit and COVID and everything else. So let's say middle 2021 before that comes in. There'll then be some transitional provisions to move us from one system to another. So I suspect the reality won't really kick in until 2022. But, you know, that's me, you know, postulating this afternoon. Something may move. You just don't know.
In terms of bringing in legislation, obviously there's so much to bringing in legislation. Would you say kind of that is relatively quick if it did come in kind of mid-2021, or is that about par for the course?
I think that's probably about as quick as it could be. You know, avoiding the kind of the obvious examples with Brexit, where the government have tried to go a lot faster and minimise the scrutiny. I don't think that would be the case here. And so actually, I think that's probably the best we could hope for in terms of doing something. Although, as I said earlier, you know, actually, and as Tony has pointed out, resourcing, I think, would be the biggest single thing that the government could do to speed up the planning system rather than ripping it up and starting again.
Yeah, I would say as well, a lot depends on what happens with the judicial review to the secondary legislation that's ongoing at the moment. I mean, the House of Lords Secondary Legislation Committee has come out and said that these changes are so radical that they ought to have been dealt with in primary legislation. And I must say I agree with that. I think that they should have been covered by primary legislation. And so if that needs to be added into the other provisions in the white paper, it's going to add to time. I think we are looking some years away yet.
Very good. Now, Tony, I'm going to stay with you for this one. What would happen to LPAs that already have local plans in place or are currently putting new plans into place? Would all of these plans be scrapped immediately, or could there be a transition period?
Well, there are certain statutory requirements which wouldn't really allow us to have a bonfire of the plans, and there will be a transition period. It has been in the past quite a complex process, the transition period, as the MPPF currently makes clear. So there would have to be a transition period, and there would have to be a due process to get the new plans in place, albeit under a streamlined procedure.
Very good. Now, it's amazing. We've had so many questions come in over the last few minutes, so it's brilliant. Do keep them coming in, everyone, and we'll get through as many of them as we physically can, because these guys are doing an amazing job answering them all. So, Paul, we'll come back to you for this one. This is a question from Paul Wilson at BWB. So, from a transport assessment perspective, if we're asked by a client to consider an office development, do you think we would have to assume the site could instead be redeveloped for food retail, which could generate a greater volume of traffic as a worst case?
So, you know, I'll defer to Paul on his views of what should go in a transport assessment or not, because he's the transport planner out the two of us. But what I would say is, if at the moment, you know, you consider what they could do to that office under permitted development, whether that's to, you know, to a different use, then I suspect the system would stay the same. Otherwise, if you're applying for an office, you know, you'd consider the office, presumably. I don't know if Tony's got a view on that, but it seems to me you've got to, you know, play the hand you've been dealt in that regard and look at what's being applied for.
Yeah, I don't see how practically you could do anything else, and I suspect that's what you know is behind Paul Wilson's question. You know, it would be an almost impossible task to produce a transport assessment, or indeed any other assessment. You can look at all the other impacts and say, well, you need to look at all the potential uses, and that's why I have my concerns about this wide-ranging Class E. You know, I think it's gone too far, and you know the consequences haven't been thought through for things like that. I mentioned in my presentation that there's no requirement for any assessment; it just happens, and I don't think it's been properly thought through.
Interesting. And now, Tony, staying with you now, if sites within permitted zones will automatically benefit from outline planning permission, how will issues such as access be addressed?
Well, good question, and I think these are some of the questions that we will be asking on the white paper. I think what's going to happen is that those zones will have to address those issues in those zones, like access, will have to be addressed as part of the local plan process before they're designated as development zones. And so, you know, again, this begs the question, you know, is the local plan process the right area to address that sort of detail, and who has the resources and the motivation to do that? at the local plan stage.
Have you got anything you'd like to add to that, Paul, by the way?
No, I mean, I think in terms of allocating sites for growth, clearly access will need to be considered as part of that allocation, and indeed through the site promotion process that will undoubtedly sit behind that. I mean, I think my concern with the allocation for growth is that really actually it's not massively dissimilar to having an allocated site now. If you've got an allocated site, actually it's the detail that can trip you up when you're bringing the application forward. It tends not to be the principle, albeit, you know, there are undoubtedly people with experiences that would indicate otherwise. But by and large, it's not the principle of developing the site that where you come a cropper on that or hit buffers. It's actually just when you come into dealing with the detail, and those issues I think will still remain under the potential new system.
Now, Paul, staying with you, this question, it's a bit of a how long is a piece of string question really, but do changes to GDO rights affect conservation areas?
So the short answer to that is it depends. If you want to do something within a conservation area, then it falls within what's described as Article 2.3 land. Some permitted development rights apply there, others don't. To a degree, it depends what you want to do, frankly. So I'm sure Tony or I would be more than happy to have a conversation offline with the person asking the question.
Yes, the new changes that I discussed to the GDO are specifically excluded in conservation areas. So the raising the height of houses and of commercial premises by up to 2 stories. It's one of the exclusions is not in conservation areas, and clearly not on listed buildings as well.
Of course, naturally. Now, Tony, we've got a question from Peter Conboy for you now. So the proposed community infrastructure levy seems to be a blunt tool that could have an adverse impact on brownfield lands with higher remediation costs. Is there any detail on how this will prevent brownfield sites coming forward for redevelopment?
I've not seen any, and I think Paul discussed this in his presentation. But I mean, one of the other things is not really being grappled with is the D question, delivery. Is how you actually convert, you know, permissions or whatever it is into development, and brownfield sites still present a huge problem and a huge challenge. And whilst the system appears to provide flexibility, and there is this provision that Paul talked about of being able to move money around, so you're not tied, so you might be able to go and spend your money on, the council might be able to spend the money on a brownfield site down the road from which they've got through an infrastructure levy payment. We are still a long way away from grappling with the problem of remediating brownfield sites and bringing them forward.
Now, Paul, moving on to you, we've heard of this top-down approach that we seem to be moving toward. Is moving towards that kind of approach necessarily a bad thing, or does it depend on the circumstance?
So I think that very much depends on who you're asking the question of. Certainly, I think there's an important function in having some degree of top-down strategic approach to planning. I think when it comes to some of the policies that are likely to come through the MPPF rather than have to be adopted specifically within local plans, I think that's probably a simplification. So I think that's got to be a good thing. I think if you ask, people on the ground, actually, I think they want to be involved when a planning application's coming forward, not be told they missed the boat because it was allocated for growth 4 years ago in the local plan when nobody picked up on it, and now they're confronted with an application. Certainly some of the things I've seen in the press would suggest that a number of constituents of Tory Shires MPs are not particularly enamoured by the prospect of suddenly having a great deal of growth thrust upon them from local government or central government. So I suspect that may not necessarily come out the other side of the white paper in the way that it's gone in. But as I say, it depends who you ask the question of as to whether they think it's a good or bad thing. And I suspect that probably depends on the result they're likely to get more than anything.
Tony,
I think there's a tension as well with neighbourhood plans. The neighbourhood plan process, which has been heavily promoted by successive Conservative governments, there's a tension there between the top-down approach and the neighbourhood planning approach. And it's ironic, isn't it, that less than 10 years ago, national housing targets were abolished, regional strategies were abolished, and now we appear to be creeping back to that. Although I think regional strategies has too much of a European flavour to its title, so we probably won't have them called that. But you know, we got rid of this system only 10 years ago, and we seem to be moving back to it again now, but in a different manner.
Why do you think that is, Tony, that we seem to be moving back to where we were 10 years ago?
Because the reality is kicking in. I think we are not delivering the housing we need, and they've tried all the other ways, and now they realise that. Paul touched very importantly on the Conservative shires. I see little prospect that local authorities in the southeast and other areas like North Cheshire would deliver the housing that's needed if they're not told they've got to deliver it. You know, I've been through any number of local planning processes with in the shires where they will die on the last barricade to prevent more housing, and so it's going to be an interesting political dynamic that plays out here as the bill goes forward.
I would definitely agree with that, Tony. Now we'll stay with you. Let's talk practicalities. For now, do we go down the route that Class E has replaced use Class A, B1, D1, for example? A former day centre, D1 use, can be converted to offices, B1, without the need for a change of use application.
Well, Paul's the lawyer here, but my view is that until the orders are quashed, if they are quashed by the courts, then they are in force, and you can exercise those rights until further notice, if you like.
Paul, would you like to add anything to that?
No, completely agree. You've got to, as I said in my talk, you've got to proceed on the basis that the use classes order stands until such time as it doesn't. There are some transitional provisions in place as to, you know, in that instance, if the person's made an application pre the end of August, then they're judged under the old system rather than the new. So, you know, there's a tactical consideration there. But otherwise, yes, no, at the moment, you're good to go, albeit with the caveats that you just need to be a little bit careful about whether there are any existing restrictions on the site, issues around in the head lease from a property perspective. There might be restrictions there that they'll need to be considered as well. So there's, you know, I think as Tony said, you know, there are wider issues at play. It's not necessarily a yes/no answer. And I certainly wouldn't want anybody proceeding on the basis of me talking now and taking that as, you know, strict legal advice they should act on. My indemnity insurer would never forgive me. But from that perspective, in short, yes.
There's so many ifs, buts, and maybes, I suppose, at the moment, isn't it? So it's very difficult, very difficult. Now, Paul, we'll stay with you. So will development outside of identified zones be permitted, for example, in a similar way to unallocated sites being considered on their individual merits under the current rules?
So I think with that, the devil will be in the detail. I can't believe for 1 second that even on areas where, you know, development's restricted, that it'll be a complete blanket ban, because undoubtedly there will be exceptions that should apply in those instances. What it is a case of you'll need to look at each site on its own merits, and there may be good reasons for planning to come forward on those sites, or it may be that you need to take a longer term view at promoting that site to move it up the hierarchy in terms of, as I say, growth, renewal, and areas that aren't necessarily ideal for development, shall we say.
Now, Tony, we've got another one for you from Darren Wallace. Thank you so much, by the way, for everyone's questions. They're amazing, and I'm sure that Paul and Tony have enjoyed answering them for you as well. But so, Tony, given the level of change occurring, is the investment in planning resources likely to change in the short to medium term, especially given how stretched some local authorities are to deal with current determinations?
Well, we are going to see an increase in planning fees. That's been foreshadowed. But at the end of the day, this is a longer term process. We find that working with colleagues in local government that it is significantly financially under-resourced, but that has other implications. There is, you know, there could be better training and officers who are poorly motivated, and members for that matter, who are poorly motivated and poorly trained. And that's not a short-term process. That's not a quick fix process. We need to recruit better into local government and bring in more people who've also worked in the private sector. I think gives another dimension to the capability of local authorities, and to motivate people better and to give encouragement to people. So even if we spooned in a lot of money tomorrow, and I just don't see the government doing that, I think it's not going to be a quick fix. We need to take a longer term approach to resourcing local government, both financially and in terms of its personal assets.
I think encouragement is definitely something that is very important, especially at the moment. Now, this question I'd like to put to both of you. So Paul, we'll come to you first, because this is something that you touched on in your presentation actually. How can something as subjective as building beautifully be legislated for?
Well, I think that is the fundamental question, really. I know the government have been keen to push a building beautiful agenda and to prioritise beauty, but as I said in my talk, what I consider beautiful, what Tony considers beautiful, are undoubtedly different things. And that's just the two of us on this call. The further afield you get, as I'm sure many people have found, actually, when it comes to dealing with conservation areas, historic buildings, at the moment you bring forward something which you think is beautiful and fitting within the character, and then actually you meet pushback from whoever happens to be looking at that on the local authority side of the fence. Conversely, you might be sat on the local authority side of the fence and see something which you think is absolutely vile coming forward because the applicant thinks that's appropriate. So I think anything that seeks to standardise design will be very difficult. What I think you will see if this comes forward is a lot of local design codes with councils specifying what doesn't tick the box as far as they're concerned, and whether that's on a local planning authority area or whether that's on a neighbourhood area, how they split that down, I suspect it'll have to be pretty bespoke, to be honest. Will be a matter for the detail in the future. Equally, based on the last question, it'll have a huge resourcing issue for the local authority, because they'll have to get somebody in to deal with that and to look at, from where was that, the whole of Rushcliffe will need to be looked at, the whole of Charnwood, the whole of Nottingham City, big areas, a lot of work to potentially prioritise beauty over functionality.
It is a very hard question, that defining beauty, like you say, everyone's opinion's different. Tony, what would you say to that question?
Yes, I mean, and more practically, we have different constituencies here. So you have the community, you have elected members, and you have professional officers. And those who work in planning will sympathise when I say, if I had £1 for every time I'd undertaken a pre-app consultation and the officers had said, well, we'd welcome a good modern design, and then it gets to planning committee and the members throw up their hands in horror and say, no, we hate this, we want a nice bit of pastiche, and similarly with the community. So it's how you get to those design codes as well, which is important, and how you get buy-in to those design codes, particularly with lay people who won't necessarily understand that process. So yes, it's all summed up by Paul's apposite phrase that beauty is in the eye of the beholder. There are other vagaries in some of these changes. In the GDPO, there is a requirement to ensure adequate or satisfactory daylight to other properties. Well, who's going to decide what satisfactory daylight is? And where are we going to get any guidance on that? So one of the problems both with the white paper and the changes, the secondary legislation changes that I've talked about, is it's replete with vague phrases, aspirational phrases that I'm sure work very well in politics, but don't work so well in the practicalities of day-to-day planning.
Absolutely. Now we're almost out of time, but we do have just one more question for the both of you. So I'll let whoever wants to jump in first on this one. Maybe let's come to you first, Tony, actually, because we had Paul first last time. Have these changes gone far enough? Will they really have that much impact, or dare we say it, could they end up being a bit of hot air? Tony, let's come to you.
Well, in terms of the GDPO changes, I think we've seen lots of tinkering with those over the years, and actually my view is it's complicated the process even more. As I said in the presentation, some of these GDPO prior notification processes are going to be as complicated as making a planning application. You might just say, well, to hell with it, I'll submit a planning application because at least I know where I'm going. So I don't think some of them are practical, and some of them, as I've said, the Class E of the use classes order I think is too far. as too far-reaching, and will, may well have to be rowed back over time, because it's the law of unintended consequences. As what will happen, what is going to happen to our high streets, and I think there will have to be a review of that before too long.
I wouldn't be surprised if we did see that, Tony. Now, Paul, finally over to you for the last answer.
So I think the use classes changes are hugely radical, for a whole myriad of reasons, some of which Tony's already mentioned, in terms of what that could mean the future looks like for the high street. I think that will have a profound and lasting effect, assuming they survive for long enough and get through the middle of October. But I do think they could have significant changes. In terms of the other changes to the planning system that are floated in the white paper, and again, I must stress, it's only a white paper, it's a consultation document, it's not legislation yet. I think some of those could have significant consequences. I think others of those, actually, it's just taking us back round in the cycle that planning and local planning seems to go through, whereby you go from a local plan to something a bit different, and then you come back to the local plan. It just keeps going round and round, and I suspect over my career we've already gone through that cycle once. I suspect we'll go through it again over the fullness of time. Tony's nodding over his kind of slightly longer period of experience, and again, I think that's just the nature of the beast, really. So expect to see localism come back round in about 2035, I think, and we'll see where we go from there.
We shall see, absolutely. Well, thank you both of you for answering those questions. Absolutely incredible answers from the both of you. Some really interesting insights as well. I'm sure so many people have learnt new things. We had so many questions. We've had a record number of attendees actually on today's webinar as well, which is fantastic. So thank you for tuning in. Sorry we couldn't get around to answering all of your questions, but I'm going to hand back over to Will now, who is the chairman of ProCon Nottinghamshire, to bring today's webinar to a close.
Thank you very much, Danielle. And as Danielle says, that brings us to the end of today's webinar. As chairman of ProCon Nottinghamshire, I'd just like to extend a very big thank you to Paul and Tony for some excellent presentations and also some excellent answers. It's nice to see a bit of wittiness in there and a bit of banter, particularly about age. But thank you very much, Paul and Tony. That was fantastic. And also a thank you to everyone concerned with the organisation of this webinar, and particular Danielle and Tom from Cartwright Communications. And last but not least, thank you all for watching. I hope you enjoyed it and found it interesting. Now, remember, you can get in touch with us at ProCon if you're interested in becoming a member by emailing us on either info@procon-nottinghamshire.co.uk or info@procon-leicestershire.co.uk, or by giving us a call on 07803 126 807. We'll be back in a couple of weeks with our next webinar about the new building regulations, so please keep an eye out on the website as registrations will be opening soon. And of course, we will email our members about this. But for now, thank you for joining us, and we'll see you next time. Thank you.